Let's now turn to the last of the big three, because we've now done copyrights, we've done trademarks. Let's look at patents. And patents are probably going to be one of the areas in which you, unlike perhaps some other emerging companies, are going to have some particular interest, because if you're trying to protect some sort of some scientific development, technical development, this is probably going to be one of the primary forms of IP protection that you want to pursue. A patent is a set of exclusive rights granted to an inventor for a fixed period of time, basically 20 years, so think about 2 decades, in exchange for the regulated public disclosure of the invention. And this line about having the regulated public disclosure of the invention is key, because trade secrets and patents are antithetical. You are going to have to, in your patent application, make what's called an enabling disclosure. You have to provide sufficient detail in your patent description, in your patent disclosure, to enable a person of ordinary skill in the art to pick up, read what you write in your specification, look at the drawings, and be able from that, without undue experimentation, be able to make, use, and practice your invention. Eventually, when the patent issues, the patent itself is going to be published, and everyone's going to be able to read it and see it, and if you have your trade secrets in it, they're no longer trade secrets at that point. By exclusive rights, one of the key things to keep in mind about patents is that patents don't give you the right to make, use, sell, or offer to sell your invention. You just heard Chuck talk about the FDA process. If you can in fact get a patent for a particular drug or a medical device, but that patent is not a license for you to then go out and turn around and sell it and make it use it. You still have to go through the various regulatory authorities and get their permission to actually go to market. A patent, don't think of a patent as a license for you to do something. Think of a patent as a piece of paper that allows you to exclude or stop somebody else from making, using, offering to sell, or selling in the United States your invention, whatever is listed in your claims in your patent, or importing into the United States. There are 3 basic types of patents that you can get, and we'll focus on the utility because that's most likely what you'll be interested in. But you have plant patents. You've heard of patented roses, for example. That's what plant patents are doing. There's only a handful of plant patent attorneys in the United States. They have all sorts of bizarre plants and vegetables sitting on their desk. Unique little niche area. But for the most part, not of concern to most people. You can get design patents. Design patents protect the ornamental, non-functional appearance of an article, the way that it works. So in other words, it's not a patent for the way it operates or the way it functions. It's basically just for the particular look. And then finally, utility patents. And what I'll be talking about for the rest of the day are going to be utility patents. These protect a useful article, the way that it works or is used. And our utility patents, when I talk about utility patents, this is the broad classification of patents that are probably going to cover pretty much anything that you do. One of the basic questions I always get with startup companies or folks coming in is what I have patentable. Generally, to have something that's patentable, you have to have 4 basic requirements. It has to be patentable subject matter. It has to have utility. It has to be useful in some way. And by the way, the barrier for being useful is really low. I mean, it's extremely low. If it has even some comedic value somewhere, or novelty or amusement value, that's enough utility. It has to be novel. It has to be new. Nobody can have invented what you invented before. And the 4th one is a sort of a amorphous gray area. It's supposed to be an objective standard, but it usually turns out to be a subjective standard. Even if what you've come up with is new, if what you've come up with is basically just such a small advancement over the prior art that's already been done before, then it's not going to be patentable. This is called obviousness, or in the case of a patent, it's patentable, being non-obvious. The test here is whether what you came up with, what your invention is, would it be obvious to a person of ordinary skill in the art to come up with your invention in light of what was known in the prior art at the time? This is, quite frankly, it's very much a gray area. It can be a guessing game. And when you file a patent application, it very much can be you're lucky to draw with regard to the particular examiner you get. I have had cases where I've been dealing with a particular examiner for 3 years, and the examiner says, obvious. They leave because there's a higher turnover ratio at the PTO. New examiner comes in, gives me a call 2 weeks later, says, I think we can allow something here if you make this small change. So Two different examiners, two different viewpoints on it. Subject matter. This is where a lot of people, have questions in the patent area. Is what I've come up with patentable? This is really what they mean. There are 4 different areas of subject matter, and I'm not going to get into the details, but I'm just going to give you a high-level view here. You can patent machines, and this is what a lot of people think of, in terms of mechanical device, a robot, a washing machine, obviously patentable. Articles of manufacture, composition of matter. This is where you get into the drugs, the biotech area, the chemical area, and processes and methods. This is where business methods or computer-implemented methods fall into. Business method patents are just a form of utility patent. They just have claims that are directed to a process or a method of doing things. What you cannot patent are scientific truths, laws of nature, mathematical expressions, and algorithms. One of the key things here, you can't patent an algorithm, you patent the practical application of the algorithm. You can't patent abstract ideas or physical phenomena. If you take one thing home with you with regard to patenting, keep this in mind, which is that you can destroy your own novelty. Unlike copyrights and unlike trademarks where you have common law trademarks and copyrights, there's no such thing as common law patent rights. To protect your patent, protect an invention, you have to timely file with the appropriate governmental authority. Patents are done country by country. You have to file a patent, with the appropriate patenting authority in that country within a certain period of time or before certain events take place. In the United States, for example, you have 1 year from the time you first publicly use or disclose your invention, or you first offer to sell your invention, or you actually do sell your invention. You have 1 year from that trigger point to file a patent application. If you don't, then you have lost all your patent rights. Patent reform. We used to be the only country in the world that had the first to invent system. You wouldn't necessarily be out of the running at that point because potentially if you invented first and you made reasonable steps to actually reduce the practice and get your patent application filed, suspect that someone filed before you, had an earlier filing date than you could potentially still be able to prove that you were the first to invent. That's what you may have heard of interferences in the patent office. That's what interferences were designed to deal with. Now we have, as of just last month, March 16th, and I can't tell you how many patents I filed on March 15th, but March 16th we went to a first to file system, at least in name. And I'll talk about basically why we actually more of a first to publish system than anything else. But basically now we're in a first to file. So the basic bottom line is file early, file often. Ownership. One thing to keep in mind, we talked about this a little bit with regard to the copyrights. In the United States, only individuals can be inventors. Corporation, other entities, other legal entities cannot be the inventor. And it's important in the United States as well. You have to get the inventorship right. Anybody who has sort of made an inventive contribution to even one of the claims, even a small part of one of the claims in the actual patent as it's issued, needs to be listed as a co-inventor. So that could be multiple people who have been working on the project. If they made an inventive contribution to at least one claim in the file and issued patent, they need to be listed as a co-inventor. Conversely, you do not want to list people such as investors, or your wife, or your husband, or your kids, or a business partner who want to be listed on the patent because they aren't actually co-inventors. They didn't make any inventive contribution. And the danger there is that if you exclude somebody who should be a co-inventor, or if you include somebody who shouldn't be a co-inventor, then the patent itself is potentially void. Ownership starts with the individual inventors. The inventors then can assign their patent rights to any entity, and they can do it collectively or individually. And for example, in the case of Vanderbilt, you already should be under an obligation to assign your patent rights over to the entity, or at least the first option of rights over to Vanderbilt with regard to that. The key thing to keep in mind, especially as you take that next step, for example, let's suppose you're dealing with licensing of some patent rights from Vanderbilt, you may be going on and developing, once you're in the private sector, some additional inventions or improvements of your own for your own company. One of the things to keep in mind there is as you go forward with patents that would potentially be your own or belong to the company, is that each co-inventor can potentially own the full rights to the invention without an obligation to account to the other inventors. There's no work for hire doctrine in the patent world. It doesn't work like copyright. So even if you have an employee for the company, unless you have in their employment agreement a written obligation to assign over to you or a present assignment over to you, you can potentially find that your company may not actually own or may actually partially own the patent rights in question. The key here is to keep in mind, get an assignment or an obligation to assign IP rights in any agreement that you get. File early, file often. And the best way to do that, one of the lowest cost ways, and of course there's money always being an issue, is to consider provisional patent applications. These are lower cost, quicker alternatives. This is a general rule of thumb. Utility patents for the initial preparation and filing can cost in a range of, say, $5,000 to $9,000. You can get a good provisional application done, and depending upon at what stage, from anywhere from, say, $1,500 to $3,500. It doesn't have any claims, so it's not the full utility application. It has no particular format. It has to have a description of the invention, and it has to have at least one drawing. But what it gets you is it gets you that patent filing date, so that you basically, that's your filing date, and so you can make a public disclosure the day after you have that provisional filing date filed, the provisional application filed. And it also allows you to use patent pending with regard to your service or your product.